5 seconds to go. Start. As the respondent Nagar Nigam failed to make timely payments of the statutory contributions in the manner prescribed under the Employees State Insurance General Regulations 1950 framed under the Act of 1948, a show cause notice dated 5th 6th June 2006 was issued to the respondent Nagar Nigam, calling upon it to explain as to why damages under Section 85B of the Act of 1948 should not be levied upon it. The respondent Nagar Nigam chose not to appear before the authorized officer and rather sought time to respond. On request being made on behalf of the respondent Nagar Nigam, the hearing was adjourned on two occasions. The authorized officer of the Appellant Corporation, while letter dated 30th January 2009, directed the recovery officer to recover damages to the tune of Rs 3,52,670 under Section 85B of the Act of 1948 from the respondent Nagar Nigam. On the basis of above mentioned letter, the recovery officer issued recovery notice dated 3rd February 2009 to the respondent Nagar Nigam for payment of the amount as determined under Section 85B of the Act of 1948. Being aggrieved by the recovery notice dated 3rd February 2009, the respondent Nagar Nigam filed the captioned writ petition number 14971 of 2009 before the Allahabad High Court, challenging the said recovery notice and seeking a direction to restrain the Appellant Corporation from realizing the amount. The learned single judge of the Allahabad High Court proceeded to allow the writ petition, wide order dated 25th October 2021, holding that the writ petitioner Nagar Nigam, respondent herein, was not covered under the Act of 1948, and as a consequence, recovery notice dated 3rd February 2009 was quashed and the amount already realized by the Appellant Corporation was directed to be refunded within 3 months. The order dated 25th October 2021 is assailed in this appeal by special leave at the instance of the Appellant Corporation, that is the Employees State Insurance Corporation Limited. Learned counsel for the appellant has placed reliance on the judgment of this court in the case of Employers State Insurance Corporation versus Kakinada Municipality and others, and urged that the controversy involved in the present appeal is fully covered by the said judgment, wherein it has been clearly held that in respect of factory belonging to the local authority, unless power of exemption is exercised by the government, it would be covered by the provisions of Section 14 of the Act of 1948 and thus liable to pay contribution. It was further contended that if at all respondent Nagar Nigam was desirous of getting the exemption from the operation of the Act of 1948, then it had to apply to the appropriate government and procure an order of exemption, and only thereafter could it seek exemption from making payment of the employer's contribution under Section 40 of the Act of 1948. Learned counsel further urged that the respondent Nagar Nigam did not appear to defend the proceedings wherein it was called upon to pay the contributions for the period June 2002 to September 2003. It also failed to appreciate in proceedings for determination of damages under Section 85B of the Act of 1948. The damages were determined by the Appellant Corporation, while recovery certificate dated 30th January 2009. However, only the consequential recovery notice dated 3rd February 2009 was assailed in the writ petition. His fervent contention was that since the recovery certificate determining the damages not having been questioned, the respondent Nagar Nigam was not entitled to challenge the subsequent recovery notice, which is consequential to the determination of the damages. Stop.